May it please the court, my name is Jonathan Harwell, a member of the Knoxville Bar. With me is at council table is Hallie Hammond. We represent the defendant appellant Cody Mashburn. If I could reserve 4 minutes of my time for rebuttal. I have raised a number of issues in our brief. I would like to discuss two of them in a different order than they were in the brief. Briefly, just to remind the court, this is a sentencing appeal. Mr. Mashburn pled guilty to aggravated burglary and criminal simulation with an agreed sentence of 2 years as a range 2 offender on the criminal simulation and 8 years as a range 2 offender on the aggravated burglary, with the manner of service to be determined by the judge. It was agreed those would be consecutive sentences. At the sentencing hearing, the defense argued for alternative sentence, including referral to a residential drug recovery program or split confinement or probation, and the judge rejected those and imposed a 10-year sentence of incarceration. The first issue I want to address, I think, is the last one in the brief, relating to the absence of a validated risk and needs assessment report, what we call strong R report. Just to summarize the facts, appropriately, a pre-sentence report was prepared in this case. Pre-sentence report indicated that the defendant was not assessed with a strong R risk and needs assessment tool due to his current status on supervised probation. The pre-sentence report was introduced by the state as an exhibit at the hearing. The attorney for the state said, "I'd like to make the pre-sentence investigation report Exhibit 1. The court said, "Be Exhibit 1. Exhibit 1 was marked and filed. That was the entirety of the discussion above introduction of the pre-sentence report. In the transcript of the sentencing hearing, I have not found any discussion of risk and needs assessment in any form. So it was not prepared. It was not submitted to the court. It was not discussed by the parties at the hearing. I think the claim is relatively straightforward. Under a statute, in fact, twice in the same statute, 4035-210, the court is instructed that it must consider the results of validated risk and needs assessment in assessing a sentence, including evaluation of alternatives. The risk and needs assessment is in one part of the statute. It's part of 8 things that has to be considered, including the pre-sentence report. Another part of the statute, it's one of 5 things that have to be considered. This court has indicated that the risk and needs assessment is essentially a predicate to a lawfully imposed sentence. There obviously has been discussion among panels of this court as to how to evaluate a situation similar to this one, in which this issue was simply not discussed. We have cited in our brief the Anthony Jared Ross decision. I cited that and praised its eloquence and wisdom, I must say, before I knew the panel that had been assigned. But I do believe that opinion adequately and appropriately addresses the concepts. This is something that is the legislature, whether judges, whether attorneys think this is important, the legislature has been clear this is extremely important.
Well, Anthony Ross doesn't set forth any kind of remarkable holding that was different from Pace or from Ailey. Insofar as the basic groundwork is concerned, all of this court's cases, every single one of them, recognize that it is error for a trial court to impose a sentence without a risk and needs assessment. Pace recognizes that, Ailey recognizes that, Ross does, Baxter does, all of the cases dealing with this issue. The real issue and the difference between the cases is, what do we do about it on appeal? Is there a waiver when there's not an objection, or in a case where, such as in Ross, where the pre-sentence report is never prepared and there are not circumstances akin to an estoppel, then a new sentencing hearing should be ordered. I'm curious in this case about why there was no objection. So the TDOC comes in and says, we're just not going to prepare one. We don't think we have to. We're not going to. We prepared one because he's already on probation, and no one said anything about it. What were the circumstances? Why wasn't there an objection?
And to be honest, Your Honor, I can't address that in the sense that there is nothing in the record. There is the statement by in the pre-sentence report indicating, as I read that statement, that is a statement by probation that in some way it's not appropriate or needed, but it doesn't make any sense to me. The fact that someone is on probation doesn't either logically or, I woke up this morning at 6 a.m. thinking they must have had a reason for that, and for the 8th time I searched statutes to see, is there any reason, any conflict between being on probation and needing a risk and needs assessment, and there just isn't.
I was going to ask, is that some kind of local custom, or I mean, I've never seen it or heard of it before either, so I was just really curious
Right,
that it was in the pre-sentence report and then that nobody addressed it at all.
I don't know of any reason why that's there. It's a puzzlement. I've asked people. No one seems to know.
Well, my practice on the trial bench sometimes was that the TDOC would not redo a risk and needs assessment if one had been completed recently. Sometimes they would come back in after a probation violation and do that. Sometimes maybe they would come back in after a new sentence. What was interesting to me here, though, is that if a risk and needs assessment had been prepared because he was on probation, even that wasn't submitted to the court, and yet there was still no objection to it.
I think that's right. It's possible that this means that we have one on file, and so we didn't do another one. But that gets back to the same problem. They have to send the one that's on file. And it's not done. There is no objection by defense counsel, no notice by the state's attorney, no comment by the court. There is nothing. And to go to the issue of waiver, what I think the court was saying in the Ross case was this is, in a way, a slightly different kind of issue than we usually have, in that we really want these prepared, and the way we're going to ensure that they're prepared is that the Department of Correction is told to do this. This is not something that falls on defense, does not even fall on the prosecutor. It is a required thing the Department.
I would push back on that a little bit. The Ross panel was not saying the way we want it done. The Ross panel was saying the way the General Assembly has ordered it to be done. The responsibility is on the TDOC and the trial court. So it wasn't this court saying, well, that's just the way it needs to be done. It was this court recognizing that's what the General Assembly is required.
I agree with that absolutely, and maybe I phrased that poorly. The we in the terms of what the legislature has said. The legislature has put this duty on the department, and if the courts allow it to be waived by the parties implicitly, then that is taking away from that. What the court in Ross also said was there is a published precedent in Rice where the absence of the pre-sentence report, again, in a situation where there was no objection or comment, that requires a new sentencing hearing, and essentially questions of waiver don't apply. And what the panel in Ross said was that's a binding precedent that I think, look at 210, pre-sentence report and the validated risk and needs assessment are given sort of the same importance. They're both mentioned in both of those portions. They're mentioned separately. And so in Ross, I think the panel appropriately said, if that's what the binding published decision is as to pre-sentence reports, then that should also be the outcome for risk and needs assessment. So the final thing I will say is I don't know that it actually matters, but this is certainly a case in which validated risk and needs assessment would have been appropriate, because what you had at the end of the sentencing hearing was the state sort of making an argument of he's got problems, but we think it's just too late for him to deal with his problems. And the judge saying, in essence, I can't have confidence that you will succeed through this program. And I was having the thought, what the judge was saying was, you're just too risky to put on probation. And the issue of whether someone is too risky or not, that's what a risk assessment is for. So this is not a case where the sentence was foregone, risk and needs assessment could never have made a difference. This is a case for which that the legislature has said this should be used. I want to switch to the other argument about the sort of unique ending of the sentencing hearing. We had a fairly standard sentencing hearing. We've made some complaints about certain comments that the trial judge made, but ultimately the judge announces the sentence, does the appropriate thing of announcing, you have this much amount of time, you're going to have this much amount of time before you're parole eligible. I'm imposing a sentence of 10 years at 35%. You'll get out, another 2.5 years. That's the order of the court. The parties then remind the court that the aggravated burglary, the 8 years of that 10 years, is a 100% sentence. And the judge then says, I'll say this verbatim, he asks some question to clarify, and then he says, so apparently there's no parole on that one, but it is punishment, you're going to have to suffer that consequence. That will be the court's order. And the sentencing hearing comes to an end. And I hope this doesn't seem like I'm nitpicking, because I think there's actually an important point here. Our claim is that the sentence that was actually imposed of 2 years at 35% plus 8 years at 100%, there was no explanation ever given for that sentence. We had an explanation that was given for the sentence the judge thought he was imposing and attempted to impose, and then when he was told that there was a separate sentence that actually he was imposing, he just said, that's your sentence. And to step back, the reason that this seems to me not to be nitpicking, I think, is what I think happens or should happen pursuant to the statute, and this is simplifying a little bit, but I think this is accurate. Judges in imposing a sentence are instructed to impose a sentence that is no greater than deserved, and is the least that is necessary. So there's consideration of where is the right line. It's not too much and not too little, but judges don't have infinite authority to pick the exact sentence that meets that sweet spot, because judges are limited to legal alternatives, sentences that are justified by mandatory minimums and statutory minimums and maximums, right? So you can't just, in the abstract, pick the perfect sentence. You're always picking among legal alternatives. And
so is it your position here that the trial court judge was considering parole eligibility when imposing the sentence? Because what it looked like to me, and maybe I'm wrong about this, but as I was reading the record, it looked like the trial court judge was imposing a sentence, and then as the trial court is required to do since 21 or 22, I suppose, has to give the defendant and the victim an approximate date when they would be eligible for release. It's like, I've already imposed the sentence is going to be a 10-year sentence, but I'm telling you that you'll be eligible for release, you'll get your parole hearing on this day. And the trial judge thought it was at 35%. State comes back and says, it's 100%, judge. He goes, okay, all right, 100%. Still the same sentence, because I was never considering parole eligibility as part of the length of the sentence I would impose. And candidly, I wonder if that would even be proper. I think as a trial court judge with me, you would never assume that someone would be paroled. And so it wouldn't be I wouldn't even be thinking about parole eligibility at 30% or 35 as I'm determining the length of a sentence. Is it your position that the trial court was considering the parole eligibility and determining the length of the sentence, and not just calculating the first time when it would come up for a parole hearing?
And if so, is that proper for him to do that?
To answer the second question first, I think that's absolutely proper. I think that is required. And therefore, I assume that the trial judge was doing that. A sentence of 10 years at 85% is a harsher sentence than 10 years at 35%.
If you assume there's release on parole, but the trial court has nothing to do with release on parole. That's a TDOC issue that the trial court has zero control over.
But I think that goes to how much harsher. But I don't think anybody would say that a 10 years at 85% is just as lenient as 10 years at 35%. It may not be exactly.
If you're not released on the first go, then it absolutely could be. I mean, you're seeming to suggest, I think here, that the trial court should assume that someone's gonna be released when they come up for hearing the first time. And I'm pushing back on that maybe gently by saying, I don't know where that assumption comes from. And I can't imagine that, at best, it's purely speculative.
Or when you say that the trial court is required to consider that, where does that requirement
Yeah.
come from in the law? Because the state's saying that's not a consideration. They pick the length of the sentence and they pick how it's served, the manner of service. And parole is not a consideration. The ruling's valid either way, regardless of the parole eligibility. So where is the requirement that a trial court consider the red date?
And even here, to piggyback off of Judge Hickson's questions, piggybacking off mine, the trial court here recognized when it was talking about the 35% release eligibility that was not guaranteed release. And so with the trial court itself saying, you're not guaranteed to be released on this day, this is when you come up for a hearing, it doesn't seem to me the trial court is considering the release eligibility date at all when fixing the length of the sentence.
So the sentencing statute says just sentencing imposed should be no greater than deserved for the offense committed. I think the percentage is part of the sentence imposed. And yes, we don't assume, and certainly can't assume, that someone is going to make their first or second or third parole opportunity. But not getting that opportunity is harsher, right? It may not turn out in every case to mean that someone is in prison for more time than otherwise, but it is something that a defendant is either going to get or not going to get. That chance at parole at 35% or 40 or whatever it is. And I guess I'm a little taken aback. I think it absolutely is, to me, it seems self-apparent that a sentence with a higher release eligibility is a harsher sentence than a sentence with a lower release eligibility. I agree that because we don't know when parole will be made, we can't say exactly that it's always going to be twice as harsh. But it is a harsher sentence.
I know your time is up. Do you have any authority that supports the proposition that the trial court must consider release eligibility when fixing the length of the sentence or the manner of the service? Other than the parsimony provision in the statute, is there any case authority that holds?
I've not seen any case authority. I think it's implicit in the statute that it is the sentence has to be no harsher than necessary, and that is part of the sentence.
It's implicit in the parsimony provision.
Yes.
Okay, all right.
And I'll reserve the rest of my time for rebuttal.
General Barker?
Good morning, Your Honor. May it please the court. Benjamin Barker on behalf of the state. Your Honors, I suppose I'll start where Mr. Harbaugh started, with the issue of this risk and needs assessment. As Your Honors picked up on, the defendant just did not object below when the state sought to introduce this pre-sentence report.
Are there circumstances here that are equivalent to an estoppel?
Perhaps so, Your Honor. As Mr. Harbaugh pointed out, the pre-sentence report said, it wasn't just not in there. It said one was not in there. And presumably defense counsel had at least looked at the pre-sentence report in order to know whether there was anything in there to which he wanted to object.
Let me ask it this. Let me ask it this way: if the and I'm not suggesting that it will or it does. If the panel follows Ross, do you lose on the issue?
Probably so, Your Honor.
This seems factually indistinguishable from Ross.
I understand how you would arrive at that conclusion, Your
I mean,
Honor.
do you come to a different conclusion?
I don't come to a different
Okay.
conclusion,
All right.
Your Honor, and I know that
All right.
I'm
So,
well aware that
I'm not presuming that any other member of the panel or myself would go the same way on this. It's an unreported case. But your brief argues that we should not apply Ross, that we should apply Pace or Ailey. And I'm not hearing necessarily something that is akin to an estoppel, like I affirmatively waive the pre-sentence report in the trial court and then claim on appeal that I didn't get a fair hearing. So I don't hear you saying that there's proof in the record that the defendant is trying to game the system. Help me with this. Did Ailey discuss the Rice line of cases dealing with the pre-sentence report?
as I stand here As I stand here right now, I don't recall, Your
Okay.
Honor.
In fact, it didn't. What about with respect to Tennessee Code Annotated 4035-210F, which specifically requires that the pre-sentence report and the risk and needs assessment shall form the basis of the sentence? Did Ailey address 210F?
Not, again, Your Honor, not that I recall.
In fact, it did not. So if we have authority that is not addressing the Rice line of cases, if we have authority that is not addressing the specific statutory language commanding the trial courts to consider and indeed form the basis of the sentence on, at least in part, specifically on the risk and needs assessment, why would we follow that authority as opposed to just the plain language of the statute and Ross?
Ultimately, it's the state's position that, with all due respect, Your Honor, Ross was just a departure from well-established issue preservation and waiver principles.
But it wasn't, because Rice is a reported case, and Rice says that when the pre-sentence report comes in, or is not part of the sentencing hearing, even when there's no objection, it's a new sentencing hearing. That's reported authority, and that's been around a long time.
I understand that Rice has been around, actually, about my whole life, Your Honor. But Rice did not, if the state advanced a waiver argument in Rice, the panel just did not discuss it. And so, Rice is so often cited for the proposition that you can't waive a pre-sentence report. And I suppose, that can be interpreted as the upshot of Rice. But Rice just does not specifically address whether a pre-sentence report can be waived. And
in fact, I think Rice stands for its holding, I think, is when there's not a pre-sentence investigation report, the trial court doesn't rely upon it, that it is a new sentencing hearing, even if there was not an objection by the defendant. And typically, you have to have an objection to preserve it. But Rice says in the context of a pre-sentence report, that's not the case, because the General Assembly has required that sentences be formed on the basis of the pre-sentence report. And then when the Public Safety Act came into being, the same thing happened with the risk and needs assessment. It just didn't attach the risk and needs assessment to the pre-sentence report. It specifically requires in two places that the trial court consider the risk and needs assessment. And in 210F specifically says that the sentence has to be based upon the risk and needs assessment. And the authority you're relying upon simply doesn't address what the General Assembly has commanded.
Your Honor, as you noted earlier, all of this line of cases, Pace, Bankston, Baxter, all of these cases that deal with this issue recognize that, and the state certainly concedes here today, that it was error for the trial court to sentence the defendant without the benefit of the validated risk and needs assessment.
So all we're talking about is estoppel then, right? That's really what we're talking about.
Yes, Your Honor. I don't know if it's estoppel as much as it is just waiver for failure to object, which is just an elementary issue preservation principle.
Well, let's talk about waiver a little bit. Let's just say starting today, for the next decade, the department does not complete a risk and needs assessment as part of any PSI. No one ever says anything about it in the trial court. It's never raised on appeal. And if it is, we find that it's waived. And that just becomes something by custom and practice that no longer occurs in sentencing in the state of Tennessee. And that's how a law becomes a dead letter when it's not enforced by the judiciary. Is it the state's position that that's what should happen with the risk and needs assessment?
No, Your Honor. Again, the state recognizes that this was error below.
But wouldn't that be the practical effect of the state's position if we adopted it in this case and if it became binding law later on?
I don't believe so, Your Honor, because it ultimately,
How?
Maybe it's the trial court's duty to, consider the
Maybe?
It is, pardon me.
Okay, so
be
it's the
more
trial
clear.
court's duty. The people of the state of Tennessee, through their representatives, has said this is the law, and this is something that trial courts have to do at sentencing. And what happens to that law if the judiciary doesn't come in and say, yes, actually, the people meant what they said. You have to follow this law.
Your Honor, there are just more players involved here than just the judiciary and the General Assembly. It is, according to the statute, the trial court's duty to consider the results of the validated risk and needs assessment in sentencing. But that doesn't undo the defendant's duty to preserve his issues by objecting to them below. And our Supreme Court in Bristol recognized this, that these issue preservation principles are fundamental to our system of justice. They promote fairness. And ultimately, it's the state's position, respectfully, that Ross makes this court an enabler for the defense bar to sandbag these kinds of issues by, withholding objections below and then raising them on appeal.
We're enabling the defense bar by enforcing the statute that was written by the people's representatives, signed by the governor.
Not by
It's the
enforcing.
law of the state. How are we enabling anything other than the rule of law?
Because the state did not object either. The
Yeah,
court
who's
did.
to say that these risk and needs assessment always cut to the benefit of the defendant? I've seen ones that most certainly do not.
I understand, Your Honor. Again, I suppose as the appellant, it's the defendant's duty to preserve errors below and raise them on appeal.
It's actually the court's duty under the statute. So the obligation is placed upon the trial court, and that's what Ross recognizes, is that the trial court has the obligation to order the creation of the pre-sentence report. The statute itself, the General Assembly, requires the risk and needs assessment be part of that. And I think that in this case, the trial court has the obligation, when considering the sentence, to consider those aspects of the pre-sentence report. I don't know that I completely agree that we're enabling the defense bar to sandbag when the state itself can say, Your Honor, the statute requires a risk and needs assessment. We request that one be prepared. It's hard for me to see that that's sandbagging by the defense bar, because the prosecutor here certainly didn't raise the issue.
The prosecutor did not. At the end of the day, it's the defendant's burden on appeal to establish, the impropriety of his sentence. And if he wants to complain about some impropriety on appeal, then he should have raised the objection below. Again, that's fundamental to our system of justice in this state. Again, it's the state's position that sentencing issues like the validated risk and needs assessment, while we recognize the authority that suggests otherwise, or says otherwise, let me be more clear, that says otherwise, it's the state's position that sentencing issues like this are not somehow exempt from ordinary, run-of-the-mill, unremarkable issue preservation principles. The defendant certainly had an action that was reasonably available to him below, and namely in the form of an objection, to nullify or prevent the harmful effect of this error, and he just did not do that. And I don't see anything in Rule 36A that suggests that sentencing is somehow exempt from that. If this court has no further questions on that issue, then I will move next to Mr. Harwell's next issue, which was the way this sentencing hearing ended. And as you picked up on Judge Greenholtz, I just don't see any authority that the defendant has cited that requires the trial court to, start over the sentencing hearing and make all new findings, when confronted with this new information about the defendant's release eligibility date. It seems that, when presented with that information, the trial court just didn't change its analysis that it had already gone through, and decided that the same sentence applied.
Is that not a huge distinction, though? And I know I'm asking Mr. Harwell one set of questions and you another one, but I'm doing that on purpose. I mean, if you're a defendant and you've received one sentence at 35%, and then you turn around and get one at 100%, that's a big deal, is it not?
Perhaps in the defendant's mind, Your Honor, but as the panel pointed out, the trial court can't just change the defendant's release eligibility date, or guarantee him any parole at all. That's up to the Department of Corrections. The trial court just doesn't have anything to say there.
But is the service percentage the part of the sentence, as Mr. Harwell argues? What if we received a uniform judgment document that had the length of a sentence, but it was left, the service percentage was left blank? Would we have a valid sentence at that point? Or would remand that and say, hey, you need to figure out what the service percentage is on this.
I'm just not sure, Your Honor, and I apologize for that.
Because if it's part of the sentence and the trial court is analyzing the sentence with the understanding that there'll be a 35% release date, and if he was mistaken with that, does that not change the whole analysis?
I don't think so, because ultimately the trial court is to determine the length of the sentence, which was not at issue here because there was an agreed length, the manner of service, whether he's going to have any sentencing alternatives or he's going to serve it in confinement, and that's about it. Release eligibility is up to the Department of Correction. Now, yes, the trial courts are required to, estimate for the defendants and the victims whether when a defendant might be release eligible, but as the panel touched on earlier, that's certainly no guarantee that that anybody's going to be paroled, and there's no requirement under release eligibility that anybody is paroled. It's just that you're eligible to be released.
But you have a right to ask for it.
You do have a right to ask for it, Your Honor, but again, that just does not guarantee release, and that is completely out of the trial court's hands there. That's completely within the purview of TDOC. I have addressed both of the issues that Mr. Harwell addressed in his argument. If this court has any further questions about those issues or any of the issues that are raised in the brief but not addressed here, I'm happy to answer them. Otherwise, the state will rely on its brief for the remainder of the issues. We ask this court to affirm. Thank you, Your Honors.
Thank you. Mr. Harwell.
I have 4 short points I'd like to make. The first, and I may have said this before, but it is our position that there was no estoppel by the defense here. I know the court in Spencer and Baxter has read some sort of affirmative action, such as little as defense counsel saying, I have no objection to the pre-sentence report, could be construed as estoppel. That seems a stretch to me, but that is not present here. There was no comment whatsoever by defense counsel as to the pre-sentence report. The second thing goes back to what Your Honor was asking about, or I guess everyone was asking about, the connection of the sentencing court in the sentencing court's analysis between the release eligibility and the sentence being imposed. And I just wanted to point the court to what the judge actually said when he came to the end of announcing his sentence. You've got 265 days into this thing already. You owe about 2 years and 9 months before you're parole eligible. No guarantee you get out. That's when you're eligible. But with your long criminal history and leaving a string of victims behind, I know you need help, but I got to think about the community too. I don't have confidence you'll be successful, so I do sentence you to the penitentiary. It's 10 years at 35%. I think this is not a situation where the judge did all of his analysis and then went and did some calculations and said, oh, by the way, this is when you'll get out. This is woven into him leading up to his conclusion of you're going to prison. The third point I wanted to make is it's not our position that when this was brought to the judge's attention that they had to suddenly stop and start over with we're going to have a new sentencing hearing now. I would not be making this argument if what had happened was that the judge had then said, I understand, and the reasons I previously gave for all of the analysis also applies to a 10-year sentence with 8 years at 100%. But he didn't do that. He didn't say anything readopting his findings, saying his findings apply to this other sentence as well, which gets us to the problem that why, out of the universe of legal sentences, why Judge Sword decided that the one that met the parsimony principle was 10 years at 85%, or 8 years at 100% plus 2 years at 35%, we have no explanation.
But it does, it was brought to the court's attention, and the court said, well, yeah, apparently there is no parole on that. but it is punishment and you're going to have to suffer that consequence. I mean, is that not the court implicitly saying all of these things I've already said still apply?
I don't think so. I think that's just him saying, it's, if we had a sentencing transcript at the end of the sentencing, the judge said, I'm giving you this sentence, it's punishment, you're going to have to suffer it, we would say that's not an adequate explanation.
Well, if that's all that was said, but that's not what we have here.
That's right. And as I say, we would be in a different position if he said, the findings I've already made justify this sentence also. He doesn't say that. Maybe he thought through that. Maybe he took 30 seconds and the transcript doesn't show he did intensive thinking, or maybe he was done for the day and didn't put any thought into it. The point is, it has to be clear on the record that that analysis has been done. And the final point I want to make is this is...
we generally don't, though. We generally don't require the trial court to put on the record that the parsimony provision has been considered. I think that's State versus Henderson from 23. So if it's an unreported case from this court, if that's the holding of this court, that the trial court need not specifically put its consideration of the parsimony principle on the record, do you lose that argument?
I don't think so. My argument is, as to the sentence that's actually imposed, there's not an explanation that takes into account any of the sentencing factors or considerations, other than it's punishment, so I guess you got to do it. I just wanted to very briefly note a factual point. This is a case where the judge had and would have on a resentencing a lot of options, including split confinement, including incarcerating on the 2 years and probating the 8 years, or incarcerating the 2 years and having a split confinement on the 8 years. So I just wanted to, this was not an all or nothing kind of situation. There are a lot of options that could have been more relevant once the judge actually understood what the sentence that he was imposing was. If no further questions, we'll rest on the briefs.
Right. Thank you. Thank you both for your arguments and your briefs. Do y'all need a break, or you want to keep going? All right, we're going to take a 10-minute recess.
All rise.